Right. So next one, Head Limited had recently issued right shares for all the existing shareholders. The total proceeds collected amounted to 200 crore, out of which 50% was planned to be used for construction of a new factory next to the existing one, and the balance to be used for working capital purpose. However, due to COVID, the proposed factory work was affected, and hence the company decided to park the 9% of the fund in a debt mutual fund instead of keeping it idle. So right share, right? So it's the IPO issue proceeds, and now it has not been used for the purpose for which it was intended. So again, that comes for reporting under the clause 10 of the CARO. Right. Similarly, the company decided to park 11% of the working capital fund in the government securities. Okay. C then decided to induct J, a newly qualified CA, as a partner in his firm. After this, the firm got an audit assignment from Messrs Bank Limited. Mr. C consulted with his partner whether to accept the offer. J told that he has a loan amounting to 75% of the FD, 75% of FD against FD of 6.8 lakh in the said bank, and feared that they cannot accept the offer. However, C told that since the loan is against FD, there is no problem in taking up the offer, but he did not want to force J in giving his acceptance. Therefore, the offer was dropped. Few months later, Mr. C passed away, and the whole firm was managed by his partner J. The legal representative of Mr. C, quoted the partnership agreement clause regarding the right of the legal representative of the deceased partner to receive a share of the profits of the firm and requested for the share of such profits. However, J informed that there is no provision as per the CA Act and denied to share any profit revenue from the firm. Agitated by the decision of Mr. J, Mr. C filed a complaint with the ICAI against Mr. J. Assuming yourself as the auditor of Head Limited, what would be your stand on reporting the deviation in the utilization of funds under the CARO? There is no need to report since the deviations were due to COVID-19. Right, then after that, the matter should be reported under 11A, the matter should be reported under clause 10, the matter should be reported under clause 16B. Right, so now what is 11A over there? It is regarding the fraud. Then to, yes, what is, yes, then what is this? There is no need to report the matter. Then it says the matter needs to be reported under clause 10, which is regarding the issue proceeds. And then the last one we have over there, 16, right? What is clause 16 over there? It is regarding the NBFC registration with RBI and NBFC, that whether the NBFC has conducted any non-banking financial or any housing finance activity without a certificate of registration, right? So this comes under the clause 10. In the above case, is the act of J to deny share of the profits to the legal representative of Mr. C right? What is the relevant provision of the CA Act? It says there is no provision as per the CA Act, but is it mentioned in the partnership agreement? Yes. Then is sharing permissible? Yes. Right, so Mr. J has no rights to deny the share in the profit since it is given in the partnership agreement. The relevant provision to be considered is 211. Right, so pays or allows or agrees to pay or allow. J has all the right to deny the share in the profit since it shall lead to misconduct. The relevant provision to be considered is 211. J has no right to deny the share in the profit since it is given in the partnership agreement. The relevant provision to be considered is 411. 411 is regarding the partnership. Right, J is correct in denying the share of profit, though the same is mentioned in the agreement. It is against the provision of the CA Act, and the relevant provision to be considered is 122, contravenes any of the provisions of the Act, regulations made there under, or the guidelines issued by the Council. No. So he has no right to deny the share in the profits as it is given in the partnership agreement. Okay. Had the firm accepted the audit assignment of Bank Limited, would it have led to invalid appointment as per the Companies Act? If yes, under what provision? Okay. Right. So now what is the amount of the FD? 6.8 lakh, right? So 6.8 and then 0.75% of that. So it's coming to 5.1. Right. So is the indebtedness exceeding the 5 lakh rupees? Yes. So as explained, since the loan was against FD, it would not be void as they accepted the offer. Yes, the acceptance would lead to invalid appointment as per the provisions of 141.3D2, 141.3D3 and 141.3C2. Right, so what does it say? 141.3D2, which is regarding the indebtedness. Right, so 141.3D3 is regarding guarantee. 141.3 it is regarding the person who is a partner or who is in the employment of an officer or employee of the company. Right, so 141.3D2 of the Companies Act, the appointment would be invalid. Okay.